Welcome to this presentation on issues of equality. In this presentation, we will be looking at equality issues regarding racial discrimination. We're going to look at equality issues regarding economics, income redistribution, and welfare. And we are going to look at equality issues regarding gender.
When it comes to racial discrimination, there's a long history of discrimination against African Americans, obviously because of slavery in this country. And we've already talked about the Three-Fifths Compromise. I just remind you of that part of the Constitution and allowing three-fifths of the slave population to count for um, representation purposes. And the Scott Sanford case, this is a pre-Civil War case in which the Supreme Court argued that slaves were protected property of slave owners, protected by the Fifth Amendment to the Constitution. So some really out of whack things in the beginning of our history. Scott versus Sanford was in the 1950s.
As a result of the Civil War, we had three amendments to the Constitution dealing with issues of equality. Amendment 13, which brought an end to the institution of slavery in the United States. Amendment 14, since the end of slavery raised the question of are freed slaves going to have citizenship and civil rights? And Amendment 14 dealt with that, which was to grant citizenship and civil rights to freed slaves. And then Amendment 15 dealt with the issue of, well, will they have the opportunity to vote? And Amendment 15 established the right to vote, that you could not be denied the right to vote because of your race, color, or previous condition of servitude. So as things worked out, though, through a series of Jim Crow laws and also disfranchisement tactics, we know that both Amendments 14 and 15 were pretty much nullified by law and by different things that were done in the South in the years following the Civil War. And a great example of that is the Plessy-Ferguson decision of the 1890s, in which the Supreme Court was looking at the issue of segregation, of the laws that created essentially two separate societies in the South and that banned freed slaves, that banned African Americans from going to many places and participating in many things. And in the Plessy case, the Supreme Court ruled that separate facilities are okay as long as they're equal, the very famous separate but equal doctrine. And of course, this really cemented segregation for a very, very long period of time in American history, put a legal sanction to it, and also created a situation in which separate was okay as long as it was equal, but no one was coming to check to see if the facilities were equal. So you end up with separate and very unequal facilities in the South.
In the 1950s and 60s, a lot of work was done to try to correct these things. In Brown versus Board of Education, the Supreme Court overturned separate but equal in schools. The Civil Rights Act of 1964 ended discrimination in all public accommodations. So any business that is public, you are no longer to discriminate, no longer able to discriminate in. And in the Heart of Atlanta motel case, the Supreme Court upheld the Civil Rights Act of '64. This was a motel that argued that the national government had no right to tell it who it could and could not serve because they were a business that operated simply within the confines of a particular state, in this case, Georgia. And the Supreme Court ruled that that's not true, that the motel was in the stream of interstate commerce, and we've seen that conversation before. And as a result, subject to the Civil Rights Act of 1964, That law and this court case really made every business in America subject to federal regulation. And of course, in the 60s and 70s, we have the beginning of affirmative action, trying to get businesses to hire minorities and then obviously women as well. We're going to talk about that subject a little later. In 65, you have the Voting Rights Act of 1965, which was the guarantee of the right to vote as well. And there's some information in your notes about that. Now, some cases involving discrimination, some court cases. Some interesting problems and issues have come up in Gratz versus Bollinger. The University of Michigan's admission policy was questioned. They had a policy that added points to the applicant's score if they were a member of an underrepresented minority. This is affirmative action as far as entering students into college. So if you were a minority and you wanted to go to the University of Michigan, you got points added to your score simply because you were a minority. The court ruled that this policy was unconstitutional, that you can't simply award points on the basis of minority status. In Grutter versus Bollinger, another University of Michigan case, this time against the law school admission policy. In the law school, the policy did not award points, but considered diversity in general, not just race as an issue. And the court ruled this policy to be constitutional, that it's okay for a school to consider race or diversity in general, but not just race, and not award points specifically for that, but it could be a consideration. So that's where we kind of are on affirmative action as far as students being able to go to college. And remember, you have to understand something that we are talking about a world that from the 50s and 60s has transformed from a place where many African Americans were denied admission to universities in many parts of this country. And so that has changed, and these are some of the ways in which we've gone beyond that to try to say, okay, we not only want to allow African Americans to come to our university, we want to encourage it. And so this is some of the ways that's been done. This is a discrimination case, the Boy Scouts of America versus Dale, kind of a different type of discrimination. Question of whether the Boy Scouts had to allow this individual named Dale, who was a homosexual, to be a leader in their organization. Essentially, this gentleman was involved in the Boy Scouts, and then he publicly stated that he was a homosexual, and the Boy Scouts said that, well, you can't be a leader in our organization because the values of being a homosexual would not support the values of our organization. The court looked at that case. Obviously, Dale sued, and the court ruled in favor of the Boy Scouts and against Dale, saying that essentially the basis of the ruling was that the Boy Scouts were an expressive association with certain values, and that allowing a homosexual to be a scoutmaster would potentially violate some of these core values. And so those words expressive association are important here. This allows essentially, this is kind of a big issue because on many levels, like what about religious schools? Does a religious school, say a Christian school, does it have to hire a Muslim who applies to work there? Somebody that might hold beliefs that we would say they're perfectly free to hold those beliefs in America, but not necessarily someone we want to have working within our organization because those beliefs would be contrary to the beliefs of the organization. And to be able to define that, your organization has to be determined to be an expressive association, an organization that expresses certain values. And that's kind of an interesting compromise on that particular issue. Issues of equality with regard to income distribution and welfare. In 1913, the 16th Amendment was added to the Constitution. It gave Congress the power to lay and collect taxes on incomes from whatever source derived without apportionment among the several states and without regard to any census or enumeration. If you go back and check your Constitution, you'll notice that it has a stipulation within it that says that Congress can't tax the states unequally. There has to be an apportionment. And the reason for that is they did not want the states to be taxed in an outrageous fashion unfairly. And so they put that clause in there. And this then would obviously make it impossible to do income taxes because income taxes are based on how much a person earns, and there would be no way to pay income taxes because each person's going to earn a different amount of money, and each state's going to have a different amount of aggregate income among its population. So there's no way to do that. So the 16th Amendment said that they no longer have to apply this previous stipulation no longer applies. And this is real important. You might ask, what on earth would cause the people of this country? Because remember, the people have to approve amendments. Three-fourths of the states have to approve an amendment. Um, this amendment was approved because people didn't think it was going to be a tax. We're going to have income taxes on the average person. Instead, they thought we would tax the rich. That was the idea. That was the reason for this amendment. That was the movement, really, that was occurring at this time. And so we have an income tax. The first income tax, I think, was 1% on the wealthiest Americans. It was very low. You should know that by the 1930s, we were taxing 75%. The level had risen to 75% income tax on the wealthiest Americans, and that tax has drifted backwards now. It's been in the 30s and the 20s. Reagan took it all the way down to the 20s, and then it's back up into the 30s now, I believe. Now, one of the things we get from sending all this money to the federal government is welfare. And you might wonder, because what we want to look at here is the idea of, in our system, what we do is we tax wealthier people at a higher rate than everybody else. Half of the people in this country don't pay income taxes because they don't earn enough money. So they're exempt from income tax. There's certain exemptions when you fill out your income tax, and under a certain amount, there's really no charge to you depending on how many kids you have and deductions, and et cetera. So about half of the American people don't pay income taxes. And the other half pay the income taxes, and the top part of that pays a much higher percentage. And in doing that, what we're doing is we're taking the money from wealthy people in this country and we're redistributing it. And where's it going? Well, it goes to a lot of different things, but one of the things that's most directly a socialist type of thing is the welfare system that we have. And it might be kind of interesting to understand where that came from. In the 1930s, when we had the Great Depression, there was a move to try to help aid the dependent children of single moms. And part of the Social Security Act, which created the pension system that we know, and which provided benefits to elderly disabled people and to the elderly and the disabled, and it also provided benefits to children, in particular dependent children of single moms. And so in the Social Security Act of 1936, ADC was the first ever welfare program in America that created a process by which some of these funds would be redistributed to poor people. And in particular, the target was poor children. And it was only poor children of single moms. If there was a dad in the house, you did not qualify because it was the dad's responsibility to provide for that family. That's in their era and how they would look at that.
So, because ADC was a very strict program and very narrow in its scope, very few people actually ever went on ADC, maybe about 1 million total at any given time. And so that's going to change in 1961 when welfare is reformed and it is done over with a new tag, and that's Aid to Families with Dependent Children, or AFDC. And notice it's saying Aid to Families with Dependent Children. And so AFDC allowed families, mothers, fathers, and children to receive aid. And so notice now fathers are included in this, and that's going to change the structure of welfare significantly. There can be a father in the home, there can be a man in the house. And what also went along with this was a big attempt in the 60s and 70s to remove the stigma of receiving welfare. In the 1930s, when we began welfare, people had a very strict idea of what welfare should be, that it should be lower than the lowest wage, it should be hard to get, and it should be temporary. And what the government wanted to do in the 1960s was kind of remove that stigma of somebody receiving welfare. And so there were lots of programs to kind of advance the idea that it was okay to apply for welfare and to remove that stigma. And so the result of these changes through AFDC and through removing attempts to remove the stigma of welfare, the number of people on welfare actually increased in the coming years from about 1 million to about 14 million. And this really kind of allows us to understand what we call the creation of the modern welfare state, because that's where we got with AFDC.
In the 90s, we decided we needed to reform the system. Under the Clinton administration, a Democratic president and a Republican Congress reformed welfare successfully by creating TANF, Temporary Assistance to Needy Families Act of 1996. This placed work requirements and a 5 year lifetime limitation on welfare. Now you have to be seeking employment to get welfare, and you can only receive it for 5 years. The number of people on welfare was cut in half, so a lot of people looked at this as very successful. However, many people transitioned to Social Security disability. Within the Social Security Act, there was the disability function, so we have lots of people now who are able to get what's called SSI because they have been able to get a court to determine that they are disabled and not able to work, and so they're able to get a government help and welfare, different type of welfare, but still a welfare program, redistribution of income. So the question for us is to consider whether or not, as socialists, um, libertarians, conservatives, or liberals, whether or not we support the idea of taking money from wealthy people and redistributing to the poor. And I would just note, please don't think in terms of if you support helping the poor, that the only way to do it is through the government. You can support helping the poor and still oppose the government being responsible to help the poor. There's two different pictures there. You can think that the way to help the poor is for the government is for people to send tax money to Washington D.C. and then they create programs to help poor people. That's one model. Then there's another model where you would suggest it would be better that people keep their own money, but be responsible to help the poor in their own communities and in their own neighborhoods. Those are two different ideas, both supporting the idea of helping the poor. I would suggest that we are certainly responsible to help the poor and that that's a very important thing, but we have to figure out which one of those models we support, the government model or the private model. Um, if you oppose helping the poor, then I just think you're off base morally. So I would make that distinction because a lot of times people say, well, if you're opposed to a particular government program to help the poor, then you don't want to help the poor. I think these are two different things we need to understand. We need to figure out where we stand, where does our political position stand on this particular issue. Then there's some really interesting stuff going on recently with gender issues. Um, we talk about women in Amendment 19. Women get the right to vote in this country in 1920. In the Civil Rights Act of 1964, obviously, that has important that has a lot of importance with regard to women and having the right to uh, access to jobs and things like that that the Civil Rights Act dealt with. Affirmative action that we talked about before, equal pay for equal work. I would suggest if you are interested in this to Google Lilly Ledbetter, who's kind of a heroic figure in the whole women's right to equal pay for equal work. There's sexual harassment issues there, lots and lots of issues regarding women and how women are treated in society and what women have access to. I think that's very interesting and important for us to think about in the sense of this course. And I think you should ask a kind of simple question here. What is equality? What really is equality? What do we think we're getting when we think of equality? Do we want people to have equal access? Do we want people to be equal, completely equal? Do we want a socialist to want to create an equal society? Um, do we want that? Do we want everybody to have the same amount of money? Do we want women and men to be treated equally? Do we want to ignore the differences between women and men? I always try to bring this up to my students. What what do we think with regard to women and men? Are women and men equal? I mean, in the sense of the same as each other. I think that the answer to that is no, they're not the same. How do you treat two things that are different the same? Now, I'm not, please be careful and understand, I'm not saying that men and women aren't of equal value. I'm not saying that. I'm saying we're just different. There's different things about men and women. We're physically different. There's a lot of emotional differences sometimes between men and women. There's other things that make us different from each other. Women can bear children, men cannot. There's lots of issues there. And I think one of the things that we're struggling with in our society is figuring out, so if everybody's supposed to be equal, maybe we should just pretend like we don't have differences anymore. Then maybe the other side of that conversation would say it's okay to be different. You can have equal value and be different. A man can be different from a woman, but they could be of equal value. It's okay to be different and still have equal value. Interesting questions. And we'll see some of this hashed out in our next conversation. So then, where this really comes to the forefront, I think, is issues of gender inequality that have to do with marriage. In and I want you to understand a couple of things here. Whenever, and obviously our society, we've moved in a particular direction on this issue. Um, Marriage has traditionally been defined as a uh, a union that's formed between a man and a woman, two different genders, one person from each gender. And in 1996, the Congress of the United States actually passed a law called the Defense of Marriage Act, or DOMA, which basically stated that that's what marriage was. But in United States versus Windsor in 2013, the Supreme Court ruled that DOMA was unconstitutional. That the court ruled that DOMA violated the rights of gays and lesbians um, to marry, essentially. And the court also ruled that the law interferes with the state's right to define marriage. And this is kind of interesting. So, what the court said was having the United States government define marriage is unconstitutional because the United States government doesn't have the right to define these kinds of things. Now, I would like you to go back to our freedom of religion conversation, some of the other conversations we've had where the government comes in and does define things very clearly for local communities. Well, in this case, in 2013, the court said, no, the government of the United States doesn't have the right to define marriage. That's up to the states. And when the government of the United States defines marriage as it does, it's violating the rights of some American citizens who might be gay or lesbian. So that's where the court stood in 2013. Well, this year, in 2015, in Obergefell versus Hodges, the court said that the 14th Amendment, again, we've talked about how important that nationalization of the Bill of Rights was, requires a state to license a marriage. If we're going to have due process and equal protection under the laws, then a state is required to license a marriage between two people of the same sex. Two people of the same sex want to get married, they should be able to, according to this ruling, and to recognize a marriage between two people of the same sex when their marriage was lawfully licensed and performed out of state. So if you got married in Maryland under the federalism laws of the parts of the Constitution, Pennsylvania has to recognize that marriage. And so, both in the state and outside of the state, a state must recognize. And notice the contradiction there from the 2013 ruling, which said the government of the United States doesn't get to define marriage. Well, in Obergefell versus Hodges in 2015, the government of the United States actually did define marriage as a union between two people, and it doesn't have to be two different genders. And that's where we are residing at this time on this question. I want to add one, I think, important point to this conversation. A lot of people got a lot pretty stirred up about the gay marriage conversation, and I think actually it's been a really the secondary conversation. I think the bigger issue is that within the last few years, within the last decade or so, we started to allow uh, two women or two men to adopt a child and be parents. And I think once we did that, we had sort of made a decision in our society that essentially men and women are interchangeable. That you don't really have to have a dad in the house, and you don't really need to have a mom in the house. You just need it's two women, two men. It's the same thing um, as a man and a woman. And I think that's interesting. I think as you think back to your experience with your parents and what your mom and what your dad brought to the table as parents, again, thinking about is it okay to be different? Do people bring different things to something, or are people interchangeable? Are human beings literally interchangeable with each other? Are we all just the same? And we don't really bring anything different to anything. That's kind of what we're saying with regard to allowing two women or two men to adopt a child. We're saying, well, you don't really need the other gender. Now, I need to clarify this. You know, there's a lot of single moms out there that have been mom and dad. I understand that. Single dads who've been mom and dad. I understand that. That's a unique thing. But normally, what's needed to raise a child is a male influence and a female influence. And that's probably that's the way it's been done for centuries and centuries and centuries. There's some natural things associated with that, but I think that's the thing I want you to understand at this point. So what we're essentially saying is, with some of these court decisions and where our culture is going, we're essentially saying that men and women are interchangeable, that they're completely equal, that there's no differences, and the differences are not significant, and that they should not be considered or uh, or in any way they should not be in any way considered. I think, and I wonder where you're at, and I wonder where your political viewpoint would be on this subject. And then again, more recently, issues of gender inequality and school sports. Um, Equal participation in athletics in 1972, the Congress passed Title IX, which provides that no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So that means that any colleges or high schools or public schools that are receiving federal money, which is about all of them, uh, have to abide by Title IX, which means that they cannot discriminate um, or exclude from participation in based on gender, based on sex. They're denied benefits to any educational program, and that would include athletics. And there's been lots of questions more recently about should girls be allowed to play on the football team? Should boys be allowed to play on girls' teams? And that's a question I think is interesting because a lot of times when I ask my students, well, should girls be allowed to play on the football team? They'll say, yeah, there was a girl in my high school and she played on the football team and it was fine. And I say, okay, well, that's all right. Then that's how you feel. But what about the opposite? Why do we not allow the boys to play on the girls' teams? And sometimes we do this, and then some controversy develops around that. And then I raise the next question: if we're going to go down the road that there's no such thing as a boys' sport, there's no such thing as a female sport or a male sport. Um, what are we going to do with having girls basketball and boys basketball? Why do we even have those two different things if everybody's the same? Why don't we just have one team and have the best players? So obviously, if we had one team and the best players, it's going to be predominantly men, male students on that team. And so there's lots of interesting questions raised by this. And again, asking ourselves the question, is it okay to have um, a sports team that's just for men? I think where this really gets into issues is things like wrestling, where some girls have been able to get on the wrestling team, and you know, there's some issues there. And I think if you'd ask any male about this, in a physical contact sport, once you reach a certain age, men are not going to participate the same when they are competing against a girl as they are a boy if it's a contact sport, because there's all kinds of physical things that enter in there that make that very complicated. And maybe not for girls, but definitely for men, definitely for boys. And so issues related to that are very interesting. They're very complicated. Where should we be on this? And in particular, should the government of the United States have anything to say about this? Or are these issues that should be decided on state and local levels?